The Practice and Jurisdiction of the Court of Admiralty in 3 Parts. By John E. Hall, Esquire. A historical examination of the civil jurisdiction of the Court of Admiralty. District of Maryland. Notice. On October 4, in the 34th year of the United States independence, John E. Hall, Esquire from the mentioned district, has officially registered a book in this office. He asserts ownership of the book titled The Practice and Jurisdiction of the Court of Admiralty, consisting of 3 parts. 1. A historical examination of the civil jurisdiction of the Court of Admiralty. 2. A translation of Clerks Praxis with notes on the jurisdiction and practice of the district courts. 3. A collection of precedents. The registration is in accordance with the U.S. Congress Act, titled An Act for the Encouragement of Learning, by securing the copies of maps, charts, and books, to the authors and proprietors of such copies during the times therein mentioned. Additionally, it aligns with the Act supplementary to the aforementioned Act, extending the benefits to the arts of designing, engraving, and etching historical and other prints. By John E. Hall, Esquire. In witness whereof, this record is maintained by Philip Moore, Clerk of the District of Maryland. Advertisement. This modest effort to explain the authority and procedures of the Admiralty is divided into 3 parts. 1. Historical examination. In the first part, there's a brief look into the historical jurisdiction claimed and supported by the Admiralty over time. It also highlights the encroachments made by common law courts, providing enough information for those interested to delve deeper into the subject. 2. Translation of Praxis. The second part presents a translation of the Praxis Suprema Curie Admiralitatis by Francis Clerk, who served as Registrar of the Court of Arches during Queen Elizabeth's reign. Lord Hardwicke considered Clerk's work as of unquestionable credit in Admiralty matters. Clerk himself stated that he wrote nothing but what he had known and seen practiced. The first edition was printed in 1679, and a translation of the third edition, published in 1722, is included in this work. The current edition, used for this translation, includes significant additions, aiming to incorporate the jurisdiction and practice of the district courts of the United States. 3. Collection of precedents. The third part provides a set of precedents useful for those with limited experience. The Admiralty practice in the United States is still evolving, and for now, the focus is on selecting approved precedents. The diversity of individuals initially entrusted with Admiralty jurisdiction in the United States, combined with limitations on appeals in certain cases, poses challenges to achieving uniform decisions. This work doesn't attempt to showcase and reconcile decisions from different districts. The author refrains from discussing maritime law principles, concentrating instead on how these principles are applied. As the author prepares for the judgment of public opinion, he looks forward to the understanding and support of his colleagues in the legal profession. He anticipates the trial with a genuine desire to contribute to the benefit of both himself and others. Part 1. Historical Essay of the Civil Jurisdiction of the Admiralty. The origin of the Admiral title. The history and origin of the title Admiral have intrigued scholars, sparking debates among profound writers. This title is commonly associated with naval officers in coastal kingdoms, and it's believed that Philip of France was the first to use it in civilized Europe around 1284 or 1286. However, historical records trace the name of this officer back to as early as 558 in France. Ducange notes that the Sicilians and Genoese were among the first to bestow the title Admiral on commanders of their naval forces. The term was thought to have originated from the Saracen or Arabic word emir or emir, a general term for any commanding officer. In English history, the first recorded admiral appears in the reign of Edward I in 1297. The explicit title of Admiral of England granted to a subject came from Richard II in 1387, given to the Earl of Arundel and Surrey. However, Spellman suggests that the title might have been used even earlier, during the reign of Henry III. The use of Admiralis Anglis became more frequent during the reign of Henry IV, especially when the title was bestowed upon the king's brother. While these historical details might interest some readers, our focus is not to delve deeply into them. We defer the investigation of this subject to antiquarians and lexicographers and move on to a more significant and less mysterious topic. Jurisdiction of the Admiralty Court. The jurisdiction of the Civil or Instance Court of Admiralty, as currently understood, appears peculiar. It primarily deals with mariners' wages, unless under seal or made unusually specific cases of bottomry, with many restrictions, and salvage, especially when the shipwrecked property is not cast ashore. Dr. Robinson's reports have shed light on a lesser-known aspect. The Admiralty Court of England entertains suits for the possession of vessels, though it avoids interference when the title is in dispute, a detail absent in common law books. Additionally, the Admiralty has an ancient and acknowledged jurisdiction to settle disputes among part owners of a ship regarding the wisdom or benefit of a particular voyage. Upon examining the current status of the civil jurisdiction of the Admiralty Court and delving into its historical roots, we are led to the belief that the various subjects it currently oversees are remnants of a once broader jurisdiction it once held, despite the limitations imposed by the restrictive statutes of 13 and 15 Rich. 2. 13 and 15 Richard II. This conviction finds support through a thorough reading of the present work. In its current constitution, the Admiralty Court predominantly handles proceedings in rem for civil cases. Notably, there was a time not too long ago when it was debated whether the court had any jurisdiction in personam. This question persisted until 1781 in the significant case of Lacoe v. Eden. If, during the reign of Elizabeth when the author wrote, the Admiralty Court's jurisdiction had been as limited as it is today, the rules of practice would have specifically addressed the cases it had cognizance of, particularly those involving proceedings in rem. However, the modern subjects of Admiralty jurisdiction, such as bottomry, salvage, and mariners' wages, are not even mentioned. Only a single chapter or title, the 41st, relates to proceedings that can be accurately termed in rem. An attachment of property solely to ensure the defendant's appearance, without the plaintiff claiming any ownership or lien, as in a suit on a bottomry bond or for seamen's wages, does not fall under this category. From the context of Mr. Clerk's book, it becomes evident that during his time, the Admiralty Court had jurisdiction over a diverse range of matters and contracts, necessitating procedures similar to those used by general jurisdiction courts. A substantial number of suits in that era involved actions of debt based on contracts. These were initially enforced by arresting the debtor, if present, and attaching his property to compel appearance if absent. The Admiralty also dealt with petitory suits deciding on property title, as well as possessory suits for mere possession. There are no indications of the limited jurisdiction that the Admiralty Court currently holds. Notably, during Queen Elizabeth's long reign of 44 years, there were very few prohibitions against the Admiralty Court, as reported by Lord Coke. These prohibitions, if accurate, were seemingly in violation of an agreement mentioned later. The Admiralty jurisdiction during that time extended to cases involving freight, charter parties, bottomry, mariners' wages, debts owed to shipbuilders and repairers, and generally, what was considered as maritime contracts. It also encompassed contracts made abroad, as these were to be decided according to civil law, which was and still is the law of the Admiralty. This jurisdiction was safeguarded by an agreement signed in the 17th year of Elizabeth by all common law judges, aiming to resolve disputes fueled by their ongoing jealousy. Failure of agreements and subsequent challenges. Regrettably, the agreements reached in the following reigns were not honored in good faith, mirroring a pattern seen in similar solemn agreements made in the 8th year of Charles I. These agreements were circumvented by judges through subterfuges that were beneath the dignity of the bench, and they were adhered to only as long as the weight of royal authority compelled them. Despite their unfulfillment, their perceived usefulness to trade and commerce led the Republican Parliament to enact them substantially through an ordinance on April 12, 1648. However, with the restoration of the monarchy, this ordinance lost its force, and the common law judges resumed their interference with the Admiralty Court, as they had done before. Although they refrained from completely stripping the Admiralty Court of its jurisdiction, they did subject it to prohibitions once again. The common law judges permitted the Admiralty Court to retain jurisdiction over cases involving bottomry and mariners' wages, as it does today, but they asserted that this allowance was merely an indulgence and a matter of necessity. Even as early as the 8th year of James I, in a case involving mariners' wages, a prohibition was denied, indicating a recognition of the indispensability of the Admiralty Court's jurisdiction in certain matters. The Court of Admiralty, in its inception, possessed and exercised a jurisdiction that aligned with the maritime courts throughout Europe. These courts emerged to safeguard maritime commerce, an aspect for which the feudal judicatures of the time were insufficient. During the Middle Ages, such courts were established across maritime Christian nations, known as Admiralty in some and consular courts in others. In southern Europe, judges handling commercial and maritime matters were called consuls, and their governing code was referred to as the Consulate of the Sea, Il Consolato del Mare. These consuls were purely civil judges, unrelated to the military or feudal system. Contrastingly, in the north, where feudalism thrived and the judiciary was seen as integral to military grandeur, both the constable, leading land armies, and the admiral, commanding naval forces, couldn't be without a share of judicial authority, especially when every minor baron had his own court. Consequently, the constable empowered his lieutenants, similar to how barons empowered their stewards, to decide on matters arising from wars. The jurisdiction over maritime affairs naturally fell to the admiral, whose court was modeled after the consular courts. The civil jurisdiction of this court focused on maritime contracts regulated by the Consolato del Mare and the laws of Oleron. Historical evidence in ancient records. Substantial evidence supporting this assertion can be discovered in the ancient records preserved in England, notably in the Black Book of the Admiralty. One noteworthy piece of evidence is an ancient statute from the reign of King Edward I. In this statute, with the consent of his barons, King Edward I ordained that the stewards of their courts were not permitted to hear pleas related to merchants or mariners, including matters like charter parties of vessels, obligations, or other deeds, even if the sum involved was under 40 shillings. Violation of this ordinance would result in indictment, and if found guilty by a jury of 12 men, the stewards would be subject to imprisonment at the discretion of the Lord High Admiral. During the reign of Edward III, the renowned Inquisition of Queensborough was established, documented in Zach's jurisdiction of Admiralty. This Inquisition detailed a list of offences that the Admiralty Court had long been authorized to inquire about and punish. Notably, among these offences was the involvement of judges in entertaining pleas related to the Admiral's jurisdiction and individuals who, in Admiralty cases, sought legal remedies in the common law courts. It is presumed that the statute, particularly the ordinance issued by King Edward I, was not intended to regulate or curtail the jurisdiction of the King's courts. It appears unlikely that the Lord High Admiral ever asserted jurisdiction or control over the King's courts. Instead, the statute was likely directed against the multitude of inferior courts that proliferated in England during that period. During that time, the Court of Admiralty asserted itself as one of the King's superior courts. In this capacity, it wielded the power to check and control inferior jurisdictions, especially the barons' courts, which held significant influence within their respective precincts during that era. The statute seems to reflect an effort to maintain the authority and jurisdiction of the Court of Admiralty in the face of the numerous lower courts prevalent at that time. Baronial interests and feudal perquisites. The formidable barons, engaged in a lucrative judicial career, were not inclined to tolerate interference in their judicial activities, which proved highly profitable for them. Their eagerness for justice administration to their inferiors was not driven by mere ambition for the honor of the task. Instead, a war of confiscations unfolded as lords sought to capitalize on forfeitures, waifs, strays, harriets, deodans, and various other feudal perquisites. A popular saying persisted until the days of Lord Coke: quod non capit Christus, capit fiscus, what Christ doesn't take, the treasury seizes. Their real motivation was securing these feudal benefits, with a keen interest in wrecks among these perquisites. Wrecks were particularly valuable to the barons, and they were often quick to appropriate vessels and goods cast upon the English coast. Wrecks fell within the proper maritime jurisdiction of the Lord High Admiral. However, the Admiral's interference was not motivated by a desire to rescue shipwrecked property for the owner's benefit. Instead, the Admiral sought to obtain it as a droit of his office. During this period, several maritime towns enjoyed their own franchises, exempt from the jurisdiction of feudal lords and their stewards. These towns, influenced by commerce and the fine arts, had a more enlightened approach. They preserved shipwrecked property within their bounds and returned it to the lawful owners. This exercise of municipal authority, including the admiral's jurisdiction, became intolerable to these towns. In the reign of Richard II, they brought their complaints before Parliament, finding a receptive audience among the barons. This led to the enactment of the famous Statutes of 13 Richard II, Chap. 5, and 15 Richard II, Chap. 3, expressly excluding wreck from the jurisdiction of the Court of Admiralty. The statutes enacted during the reign of Richard II significantly restricted the jurisdiction of the Court of Admiralty. The first statute stipulated that the Admiralty should only concern itself with matters occurring upon the sea, as was the practice in the reign of Edward III. The second statute specified that the Court of Admiralty should not have jurisdiction over contracts, pleas, quarrels, or other matters arising within the bodies of counties, nor over wreck. Despite the enactment of these statutes, historical records suggest that the Court of Admiralty continued to exercise its ancient jurisdiction with minimal interference from the common law courts until the reign of James I. Even during James I's reign, when Lord Coke presided over the bench, prohibitions were not particularly frequent. In the subsequent reign of Charles I, the agreement reached under Elizabeth between the Courts of Admiralty and common law was renewed, indicating a temporary harmony in settling their respective jurisdictions. It was only during the reign of Charles II that a significant and prolonged struggle ensued between the authorities of the Court of Admiralty and the common law courts. This conflict ultimately concluded in the triumph of the common law, marking a turning point in the balance of jurisdictional power. The jurisdictional contest between the Court of Admiralty and the common law courts was fiercely waged, with notable contributions from skilled civilian jurists such as Exton, Zach, and Godolphin. These jurists, known for their eminence in the field, presented compelling arguments and demonstrated ingenuity and logical prowess in defense of the doctrines they upheld. Despite the evident weight of their arguments, the ultimate outcome favored the superior power and influence of the King's Court of Common Law. The contest, marked by legal debates and intellectual rigor, concluded with the prevalence of common law authority over that of the Admiralty Court. Civilians' interpretation of statutes. The works of civilian jurists such as Exton, Zach, and Godolphin provide valuable insights for those seeking an in-depth understanding of the ancient jurisdiction of the English Court of Admiralty and the encroachments, now considered usurpation, by the common law courts. These jurists interpreted the statutes of Richard II in a manner that virtually deprived the Court of Admiralty of any civil jurisdiction, a reading that may not align with the intended scope of the law. It is suggested that the original intention of the framers of the law was to leave the Court of Admiralty, except in matters of wreck, with the same jurisdiction it had exercised in the reign of Edward III. The jurisdictional dispute extended to contracts, where the common law courts contended that if a contract was made at sea but was to be executed on land, or made on land to be executed at sea, then the common law had exclusive jurisdiction over the Admiralty. The civilians, however, took a more rational approach to interpreting the statutes. They argued that contracts made at sea or to be performed at sea should encompass those of a maritime nature, even if the instrument proving them was made on land. Examples cited include contracts of affreightment and similar agreements, which, by tradition, fell under the Admiralty's jurisdiction during the reign of Edward III. In England, the question of jurisdiction between the High Court of Admiralty and the common law courts has been resolved, with the High Court of Admiralty acquiescing to the restrictions imposed by the common law courts. However, in modern times, there seems to be a certain degree of regret expressed by the common law courts regarding the extent to which these encroachments were pursued. Decisions rendered since the time of Lord Mansfield reflect a more moderate spirit compared to the more assertive positions taken by his predecessors. In recent adjudications, the Admiralty jurisdiction has been explicitly clarified and fortified on certain points where doubt existed. Moreover, there are instances where the jurisdiction has been expanded, as seen in suits involving bottomry contracts under seal. Notably, in the case of Monetone v. Gibbons, 3-term Rep. 267, it was determined that the jurisdiction of the Court of Admiralty is not contingent on the locality of the contract but rather on the subject matter. This principle aligns with the long-standing contention of civilians. There is now an opportunity to apply this principle liberally and, in doing so, potentially restore to the Courts of Admiralty a portion of the jurisdiction that had been curtailed by the unwarranted apprehension of the common law courts. Constitutional implications, Admiralty jurisdiction in the United States. The discussion on the historical evolution of Admiralty jurisdiction holds relevance in the context of the United States Constitution. According to the Constitution, the United States is endowed with judicial power in all cases of admiralty and maritime jurisdiction. The crucial question arises, does this jurisdiction mirror that which the High Court of Admiralty formerly possessed, or is it constrained by the statutes of Richard II and the corresponding English court decisions? In the case of the Sandwich, Pet. Admiral 233, Judge Winchester from the Maryland District articulated a viewpoint suggesting that the construction and application of the statutes of 13 and 15 Richard II in England should not be automatically extended to the United States. He noted instances of conflicting decisions by different judges under these statutes. Judge Winchester, renowned for his profound legal insight, hinted at the challenge of reconciling inconsistent decisions and avoiding erroneous conclusions. His perspective remains influential in American jurisprudence. There is a leaning towards the opinion that the terms admiralty and maritime jurisdiction in the U.S. Constitution should be construed broadly to empower district courts with the powers historically exercised by the High Court of Admiralty. This interpretation is driven by the recognition of the paramount importance of maritime commerce, the need for certainty and stability in its operations, and the diverse nature of these operations, all of which necessitate a comprehensive admiralty jurisdiction. Further documents on admiralty jurisdiction. While we find the question of admiralty jurisdiction under the U.S. Constitution intriguing, we recognize that the investigation is best left to those with the expertise to delve into it more thoroughly. For specific details on the current jurisdiction of the Civil or Instance Court of Admiralty in England, as well as the laws and procedures guiding its proceedings, readers are directed to Brown's Civil and Admiralty Law. This work provides a comprehensive, methodical, and illuminating treatment of the subject. In the United States, there have been a few notable decisions impacting admiralty jurisdiction, including those found in 1 Dol 49, 3 Dol 297, and 4 Cranch 24, 443, 447, 452. However, as our admiralty system is still in its early stages, the full extent of its powers remains to be seen. The procedures for admiralty proceedings are likewise unsettled and diverse. To assist in navigating this evolving landscape, a collection of approved precedents is appended to this introduction based on the advice of a knowledgeable friend. For those curious about further exploration of the subject covered briefly in this introduction, the following documents are included. 1. The Ordinance of Hastings by King Edward I on Admiralty Jurisdiction, extracted from the Black Book of the Admiralty. 2. The heads of the Articles of the Inquisition of Queensborough from the 49th year of Edward III, conducted by 18 expert seamen before the Admirals of the North and West and the Lord Warden of the Cinque Ports. 3. The Articuli Admiralitatis, or Remonstrance of the Court of Admiralty to King James I, complaining about the violation of articles agreed upon in the 17th year of Elizabeth, along with Lord Coke's evasive answer. 4. The resolution signed by all common law judges in the 8th year of Charles I on admiralty jurisdiction, later disavowed. 5. The ordinance made by the Republican Parliament of England in 1648 on admiralty jurisdiction. Summary. The exploration of admiralty jurisdiction traverses historical, legal, and constitutional dimensions. The question of whether the jurisdiction vested in the United States under the Constitution mirrors that of the English High Court of Admiralty or is constrained by certain statutes and English court decisions remains a thought-provoking issue. While acknowledging the importance of this question, the discussion suggests leaving its investigation to those better qualified. Reference is made to Brown's Civil and Admiralty Law for a comprehensive understanding of the current jurisdiction in the Civil or Instance Court of Admiralty in England. In the United States, where admiralty jurisdiction is still evolving, a few key decisions have impacted its scope. The system is in its early stages, and the extent of its powers and procedural norms is yet to be fully realized. To aid in navigating this evolving landscape, a collection of approved precedents is provided. For those interested in a deeper dive, appended documents include historical ordinances, articles, and resolutions related to admiralty jurisdiction. These documents shed light on the historical context and legal evolution of admiralty jurisdiction, both in England and the United States.